All rise. The Honorable Justices of the Supreme Court. Hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court, now sitting.
Please be seated. Good morning and welcome to the Kansas Supreme Court. I'm going to ask Mr. Doug Shima, the clerk of the appellate court, to please call the 9 a.m. docket.
Thank you, Your Honor. The 9 a.m. docket for Tuesday, December 10th, 2024 consists of one case. Appeal number 125734, Austin Properties LLC versus the City of Shawnee, Kansas, Johnson County. 20-minute argument on both sides, briefs on both sides.
Good morning, may it please the court. Melissa Sherman for the appellant, Austin Properties. And I would respectfully ask to reserve 5 minutes rebuttal. I am present and ready for argument.
May it please the court. Good morning. Andrew Holder on behalf of the appellee, the City of Shawnee, Kansas, present and ready for argument.
Your Honor, that concludes our 9 a.m. docket.
Thank you, Mr. Shima. Council would please come forward in 125734, Austin Properties LLC versus City of Shawnee, Kansas. Let's do it in the company.
May it please the court again. My name is Melissa Sherman and I represent the appellant, Austin Properties, the property owner in this case. This case is about bias against an apartment development causing elected officials, in this case, city council members, to abandon their quasi-judicial roles and adopt the sentiment expressed by the neighboring property owners, violating due process. This court has long held that zoning may not be based on such a plebiscite of the neighbors. It is impermissible for a plebiscite of the neighbors to exist because, like here, neighborhood opposition to development is often based on irrelevant and irrational concerns. There are two issues for the court's consideration today. First, whether the city violated Austin's due property rights by not complying with KSA 12-757D, which sets forth three options for a city council considering a proposed zoning amendment.
I've got a couple questions, but before we get started, could you explain or tell us what the status of your client's wishes pertaining to the property? This was 6 years ago or 5 years ago when all this happened. Is it still the desire of of Austin Properties to proceed with its development?
It is. Thank you, Your Honor. My client very much wants to proceed with development, has been unable to proceed because the development that was proposed is the only one that my client has determined is economically feasible. So he has been, and Austin Properties has been in a holding pattern while this issue is being litigated.
If that's true, then this business about 757 requiring the city to send back the plan to the planning commission for another review wouldn't do any good if this is the only way they can develop the property, right?
Good question. I don't think so. Respectfully, I mean, the whole reason that is set forth in the statute is to acknowledge that there can be some give and take. If there are concerns that are expressed by the city council members, they have the ability to state those concerns, and then it can be sent back to the planning commission, and there can be a thorough, cogent discussion between the property owner, the city, and the planning commission about addressing those concerns. That option was not provided today.
I understand it wasn't provided, but it gets down to sort of a harmless error kind of thing. If you guys can't change your development in a meaningful way, then what's the point of sending it back down?
Well,
review.
Yeah, and I don't know that my client has made the decision that it can't change the development in a meaningful way. Whether that's reducing the number of buildings further, or further doing further analysis to address the traffic concerns, or pushing the city to make any necessary improvements around the property to address traffic that would allay the concerns that have been raised by the neighbors. I think there are a number of different avenues and issues that can be discussed and worked through at the Planning Commission that would allow the project to potentially move forward.
When you frame your issues, several of them and in your briefing, but really don't explain it, that this somehow violates due process rights.
That's right.
And are you suggesting that 757D and F are the due process protections, or what, in what way? Because you really don't spell it out for us, and you just kind of throw it in there and then conclude this violates due process. I understand it might violate the statute, but how are you kind of encompassing your due process? I don't follow it at all.
I'm happy to address that. Specifically, because the statute is an authorizing statute, the city can only act as set forth in the statute. And one of the options, remanding it to the Planning Commission, represents the idea that if there are concerns, my client as a property owner should have the ability to address those concerns before the property is killed, or before the project is killed.
And how is that a due process concern?
Property rights are sort of central to the bundle of rights that we have. A property owner has the ability to develop its property as it sees fit, subject to, of course, reasonable restrictions. And those restrictions are subject to due process. There can't be unreasonable restrictions placed on the development of property. When that happens, clients like mine, property owners, are deprived of their rights. That is what we contend happened here.
If we interpret 757D the way you want us to, which would require the project to go back to the Planning Commission, are we done with all the other issues? Do we need to even address anything else?
It's a fair question. In short, I don't believe so. We would respectfully ask you do address the second issue here, the reasonableness of the decision, because we believe the decision itself was wholly unreasonable, warning a directive back to the city council that it approved the amendment. However, if the court would define in our favor on the first issue, the statutory issue, I would have to agree that that would address our concerns.
Let me kind of, the remedy is challenging, because what we have before us is a denial of your summary judgment and a granting of the summary judgment district court that was affirmed by the Court of Appeals. The Court of Appeals uses a rationale that 757F operates independently from subsection D. I understand that. But if I think your argument is D applies, but it would require the supermajority. Correct?
That's correct.
Because there's a valid protest petition.
Yes.
And then the city, when it voted didn't have their 3/4 majority, didn't take any other action and deemed it denied.
That's correct.
But this D requires several different things. It requires either you accept the amendment, or that you send it back, or that you deny it with a 2/3 majority. The latter two never happened here. So does it go back for a newly comprised city council to consider whether they deny it on a 2/3 majority? Because when you don't approve, that doesn't mean you deny it. That's two different things. Do they have to go through that process and decide between either remanding it back to the Planning Commission or denying it? Answer that question first. What happens here if we agree with you and we apply F to the remand proceeding? So what do we do?
I think it just goes back for a vote, whatever that vote may be. To the city council.
To the city
Yes.
council.
So they either vote anew and get the 3/4 majority, they override the recommendation with a 2/3 majority, or they send it back.
Okay, so that's where you see this. If we adopt your interpretation, that's what would happen. And then
Correct.
let's take it the next step. Let's say it goes back. Let's just think ahead here. If it goes back to the city planning or to the zoning planning people, and they make some revisions and then send it back. Doesn't the F still apply because we're still dealing with the same amendment? And so it still would require a 3/4 approval upon that reconsideration.
I 100% agree. There's actually a Attorney General opinion from Bob Steffen, and it's 80-149, 1980. The Westlaw citation is 1980 Westlaw 117827. And that's precisely the opinion that he gave, that there's only one shot that you get on filing protest petition. That's 14 days after the initial public hearing. That triggers the 3/4 majority, and that holds true throughout. That same analysis was given in a recent Kansas Bar Journal article, 91-APR JCAN-BA 55. That was by Robert Parnicott. Mr. Parnicott interprets the statute just like you have, Your Honor. If there remains a sufficient protest, so if there was a protest petition in the first instance, that stays throughout the process. So if it's remanded and then it's recommended back to the city council, 3/4 majority still applies. So at that point, the city council can either adopt with a 3/4 majority, or they can modify it, or they can do nothing. And if they do nothing at that point, then the application is denied.
And that's a different application. The Court of Appeals concern was that it creates a kind of a shortcut to get back to a majority without
Yes, and
reviving the protest position.
we do not believe that it does.
I want to make sure I heard you right. So if we rewind the tape to go back to the city council saying you only took one vote, the 3/4, and that didn't work. And the protest petitions is still in place. I wasn't sure whether I heard you say they can amend, they can try to deny. And if they do either of those things, I guess I was wondering if they do either of those things, that's not a denial. I mean, the amendment, you were just saying if they vote with the 2/3, that's a denial.
In the first instance.
Right.
In the first instance, if there's a 2/3 override of the recommendation to adopt, that is a denial.
Right.
Because
There doesn't
there,
have to be any reason, it kind of gets into your reasonableness argument on the second issue. But if a 2/3 majority votes to deny, can they just do that without, they just vote to deny and the whole reasonableness concerns are there or not there?
I think the reasonableness concerns are still there. I think the city council still has the requirement to judge the application based on the, benefits to the public and the benefits to the property owner. I think that still holds.
Why would we decide the reasonableness issue now then? Because it'll be a whole new ballgame with whole new reasons if we send it back.
I see your point, Your Honor, and I think there is some merit to that. Again, our position is the city council should be directed to adopt the amendment because it completely violated and shirked its duties. And if it had followed through on what it should have done, our client would be in a far different position. But I understand your point, Your Honor, and I really can't argue against it. As I said before, if the decision is in our favor on the first issue, the procedural issue, then it should go back for a new vote.
When you have this ping ponging between the governing body and the planning commission, is there anything by statute or city ordinance that requires another public hearing?
There is not, Your Honor.
So that going back to the triggering language, your argument is the triggering language is 14 days after the public hearing.
That's correct.
It.
Yes, and that's exactly what Bob Steffen communicated and directed and gave guidance on in his Attorney General opinion.
Can you give me the site again of that Attorney General?
Happy to. It's 80-149. And the Westlaw citation is 1980 Westlaw 117827.
Thank you.
And specifically to the issue of whether there will be sort of this endless loop back and forth between the city council and the planning commission. Respectfully, that's a farce. It's not going to happen. And I again refer your honors back to the Bar Journal article. The statute itself says it goes back to the planning commission, and then if it comes back to the city council, one of the options the city council has is to take no action. It is at that point that no action means there is a denial. But
Oh, sorry, I didn't mean to. Go ahead and finish your argument there.
well, and the point is that respects the process that there should be a give and take or some ability for the property owner to address concerns that have been made. Under the current circumstances, we had no opportunity to address the concerns that were made. The city council members get up on the, on their, podium and say that they've got generalized concerns and we have, a particular intersection that may have problems. In that instance, we have no ability to address it. That's exactly why that option exists.
Is reasonableness a question of law or fact?
It's a question of law.
Why does our case law then defer to the municipality's decision on reasonableness? Why is some of our case law suggested we give deference?
That's a good question, Your Honor. And I think it's because the court does not want to substitute the decision-making that happens at the local level for judges' decision-making. That being said, there still are parameters that this court has set. And specifically in the City of Topeka decision, it talks about persuasive evidence. It specifically says some of the evidence that was presented on traffic concerns was not persuasive. Therefore, the court specifically was considering the quality of the evidence that was presented.
And maybe the larger question behind my initial question is, what is a court's role? Why should courts be meddling in these sort of planning decisions? I guess it seems like a local political sort of question in some respects. But maybe you need some protections for due process and constitutional rights. I'll grant you that. But what is the judiciary's role in this sort of review of planning decisions?
I see my time has expired. May I answer your question?
If the chief will allow it.
May I answer his question? I think just for the final point that you made to preserve due process, there's an understanding that we have elected officials who certainly want to represent their constituents. And sometimes that might mean you're going to do what your constituents want in lieu of looking at the broader picture. So here that would mean in lieu of looking at the apartments that are going to come in and create jobs and serve a need in the community. It does go back to due process. Property owners have rights. They should be able to develop their property to the fullest extent permitted under the law. And without this court sitting as a gatekeeper, city councils could do whatever they please. Thank
With
you.
the chief's indulgence, I have a couple of quick, I think they're quick questions, both on reasonableness. The first is that, as I understand it, the initial appeal was taken by your client via KSA 12-760, which allows a person aggrieved by the decision to file an action to determine the reasonableness of the final decision. Does that foreclose your statutory argument? In other words, is the statutory argument even properly before us here, given the way this case arose?
I believe it is, Your Honor. And in particular, this court has said that one of the issues in determining zoning appeals like this is whether the law was properly followed. That is in Combined Investment Co. 227 Can 17.
I'm sorry to interrupt, but quickly, does that case law wrestle with the language in 760?
I don't.
I mean, I don't really see that. So that's more my question is I want you to address the limiting language in 12-760.
I don't believe it does. If the action taken by the city council did not follow proper procedure, it is per se unreasonable. That is what we would say. And again, that's why the statutes have set up sort of this two-part analysis.
Does that mean that you agree that all of your arguments are subsumed under the reasonableness question?
I think generally, yes. Although, I mean, they're sort of two sides of the same coin.
And we have precedent that says that a zoning action can be, quote, both illegal and reasonable. That would seem to undermine your position.
Yeah, I don't know what case you're citing, but I
That's
mean.
the Manly case, Manly
Okay.
versus City of.
But there are cases, you know, that this court has held, Zimmerman, for instance, that has specifically said, if you do not follow the statute, then the actions are void. And that issue arose in an appeal just like this one, under I believe the same statute that we appealed under.
Okay, and real quick, my last question is, do you think, or I just want you to respond, I think I know what you think, to the argument that the mere existence of a protest petition means that any decision of a council to essentially agree with the protesters is ipso facto reasonable, just the fact of the protest petition itself?
No, I don't believe so.
But why not?
I mean, this court has said in Golden that there are a number of factors that must be considered. And the whole body of case law on plebiscite of the neighbors acknowledges the fact that if there is public opposition to a project, that it can be based on things that aren't appropriate, unfounded fears. We had one of the council members talking about people being concerned about crime, all of the things that you hear about when apartment is coming to your neighborhood.
Does that run counter to the fundamental representational nature of the city council position? I mean, they're supposed to represent the interests of their constituents.
That's correct. But in this instance, they are serving in a quasi judicial capacity.
Okay.
Their directive is to judge the evidence, look at the evidence. That is what they're supposed to do.
So it's that fact that they're not acting as pure legislators.
That's
essentially.
correct.
Okay.
Yes, that's right. Thank you. And thank you for the additional time.
Mr. Holden?
May it please the court, Andrew Holder on behalf of the appellee, the city of Shawnee, Kansas. This appeal presents two core issues, which I think have already been touched on. The first one is a procedural issue, which is how the city's zoning ordinance, which mirrors KSA 12-757, the interplay between subsections D and F as it relates to what the city did here, and then obviously the substantive issue of the reasonableness of the city's decision. So I'll start with the issue I think that a lot more time's been on it, which is the procedural issue and the interplay between subsections D and F. I think that when the court is looking at these two, you start with the initial question of, are these two subsections in conflict to some degree? And I think that the answer to that has to be yes. When you look at subsection D, it authorizes the governing body to approve a zone or a planning commission recommendation by a simple majority, whereas D says that if a protest petition is in play, it requires a 3/4 supermajority. So
Why is that a conflict? Doesn't that just clarify the effect of a protest position?
I think that it can't be both at the same time. I mean, facially, there's a conflict between simple majority and supermajority. That's the conflict. It can't be both at the same time. And so that's where I think the Court of Appeals correctly found that as to that conflict, the more specific subsection controls in that subsection F here. I do want to touch on one clarification that hasn't been touched on yet, which is how American Warrior plays into this. And I just want to touch on this briefly, which is, I think American Warrior narrows the scope of what actually falls under 12-757. If you look at that case, it reads it more narrowly than that subsection had been interpreted in the past. And where I think that leads us here is a distinction without a difference, but it is a distinction. The same authorizing statute, which is 12-755, allows governing bodies to enact conditional use permits, special use permits, and also regulations pertaining to planned use developments like the one here. And I think that what that opinion tells us is that we're really playing under home rule authorities in the city's ordinance. And the reason I say that ultimately ends up being a distinction, but one with that difference here is the city's ordinance contains the same language as 757. So we end up in the same place, but this needs to be looked at under the city's ordinance rather than the statute itself. So when we look at these two—
Does that have any practical implications?
I think it narrows the reach as it relates to here, but I mean, substantively, the way the court would interpret the ordinance would presumably apply to the statute as a whole
Okay.
other places. So
It seems like the 0-030, that the ordinance just basically mirrors the 757.
right, and I completely agree with that as far as this goes. So I don't think that that takes us completely out. It's just we're looking at the statute doesn't apply here, the ordinance applies. So when we're talking about the interpretation, it's still the same idea, which is when you look at the interplay with the two, I think that what the Court of Appeals really struggled with and what I struggle with is the question of if this applies the way that Austin argues, and if it goes back down to the Planning Commission, what happens there? And that's where I think that the statutes just don't have the answers for us.
But it's not the role, here's where I disagree with you, and so you can set me straight. I think the statutory analysis by the Court of Appeals goes off the rails right at the start because it's not the typical way we analyze statutes. First, you look at the text and you follow the text. That's the legislative intent there. And the Court of Appeals never made another finding, which was that the statute, that the two subsections were ambiguous. And then they launch off into what you're talking about, which is a policy concern. And I don't think courts ought to be playing policymakers. And that's what I see the Court of Appeals doing. The Court of Appeals is trying to inject some kind of its own common sense into how this process ought to work. But that ain't the way we do it. We just read the statute and follow it. So why do we get to look at what happens if it goes back?
Well, and I think it goes back to the issue of statutory interpretation, which is that within subsections D and F, there's no clear guidance that says where F is triggered, everything that D says still applies. And so that's where I think the Court of Appeals got into trying to ascertain what the legislative intent was through trying to apply a common sense approach to the statute.
I just don't see how it gets there when the text is plain on its face. I just don't see a problem here. And they never found the statute was ambiguous. Which is the next step in statutory interpretation.
Well, and I think that's where you get into when you have subsection F. I think that the Court of Appeals found that the ambiguity inherently lies with, okay, a protest petition has been filed, so we know from F, everybody agrees that a 3/4 supermajority applies. But F itself doesn't contain any other limitation on what the governing body may or may not do. And so the ambiguity is, does that mean that they're not otherwise limited, or does that mean that the limitations from D come in? And that's
my problem is the court never said this statute is ambiguous. I did a word search on this thing this morning because it bothered me last night. The only place where the word, ambiguity shows up is in a piece of boilerplate quoting something, quoting some other case. It's not a finding by the Court of Appeals. And then the word ambiguous relates to a different part of the statute. It's in the earlier part of the analysis that the Court of Appeals puts before it gets to the peanut here. It just seems to me the court launched off into a policy-making role without touching all the bases it has to touch before it can do that.
I think you're completely correct that the text of the opinion itself doesn't say that there's an ambiguity between the two of them, although I think what it does say is that subsection F doesn't spell out what else has to happen. And I think that in and of itself is an acknowledgement that there's.
Why does it have to?
Well, I think that it doesn't have to. That's the point here, is it doesn't, because it doesn't say we have to determine whether that means that. I think there are two different options. Either that means that the governing body can say we can either approve it by a supermajority, or we're otherwise not limited in what we can do, or approve it by a supermajority, or the options spelled out in D. I think that's where the ambiguity arises.
And I go ahead, Chief.
No, go ahead.
I'm struggling because to me, when I read the statute, it says if you want to approve it, when you've got a protest petition, that takes 3/4 of a vote, of the majority. Everybody agrees with that. Then it says, if you want to kill this thing, it takes 2/3. And they never killed it.
And I think as it relates to this specifically, what the Court of Appeals talks about is if we really apply it that way, if we just apply the straight text and assume that there isn't any ambiguity, problems arise. Because you can imagine a situation where, for example, you had a 3-member governing body. And if you have 2 members that support a zoning application and you have one, and we assume that the one doesn't support it, has a reasonable basis for that, right? And we've got a protest petition in play. All 3 have to approve it to get to the supermajority. So that option's not on the table. 2 of the 3 don't support overriding the planning commission, so that's off the table. So the only option left, if we apply the appellant's argument, is to remand that down to the planning commission. At that point, if the planning commission keeps things the same, then the question becomes, what do we do when it comes back up? And one of the arguments raised is, well, when it comes back up, the governing body can elect to do nothing. But if you've got a small governing body and 2 of the 3 support it, they wouldn't support doing nothing. So that option's off the table. And so what you've got in that situation is a complete gridlock that can't be resolved unless either.
I'm not following you at all. What's the grid? And I appreciate the facts here are different, but you're right. There are a lot of councils that only have 3 members and commissions that only have 3 members, but I still don't see what the problem is. It's the supermajority would still apply to the reconsideration if it went back. And at that point, it ends, doesn't it? If they don't have the supermajority, you get one crack at it when it comes back. And if they don't pass it, it's over.
Well, I think that's not what subsection D says. I think subsection, if we're eliminating the simple majority requirement after it, and that option's off the table, and if 2 of your 3 governing members don't support do nothing as an option, then I think they could continue to send it back down to the planning commission. And that's where you get into this ping-ponging back and forth that can't get resolved.
Okay.
Back to just looking at the text of the statutes. F begins with the words except as provided in subsection G. Does that hurt your argument because there's nothing that accepts any other provision? Does that inform us that D must apply because the legislature didn't accept it?
I don't think so. I mean, subsection D is its own separate part that got added later in there. I think that when you look at F, it just has one limitation. That's the supermajority. I don't think that unless it's applied in G, it has any application to the interpretation here.
I understand that G doesn't apply, but what I'm suggesting is that if the legislature took the time to accept one subsection, but did not accept other subsections of the statute, does that tell us we have to look at all of the other subsections as we apply and interpret F?
I think that not if subsection D is in plain conflict with it. I don't think that you can. That's where I think the inherent issue here is.
So we in that situation, you suggest we would rewrite or add, effectively, the Court of Appeals has added words to the statute. And that's essentially what we have to do under your interpretation, I think.
I don't think that they've added words. I think they've just applied the sole limitation in F and said, where F is triggered, this is the only limitation on what the governing body can do. That's where I think that, I think that's where F applies, the way the Court of Appeals interpreted it. You apply the supermajority statute, and otherwise the governing body's decision-making is not limited by D or any of the other sections. I don't think that they've added any language to that statute.
Can I direct you back to 757D? I just want to understand what your understanding of the procedures in D are. And you were talking a minute ago about what happens under D3 when a commission returns the recommendation to the planning commission.
Right.
and you were describing this eternal loop that could occur. I wanted to get your take or your understanding of the statute's language about when the recommendation comes back from the planning commission. In other words, the governing body has returned the recommendation to the planning commission. And then they've either altered it or not altered it and sent it back
Right.
to the governing body. And then the statute says that the governing body by a simple majority may adopt it. And here's the language I want to ask about, or it need take no further action.
Right.
What does that need take? Does that mean kill it by silence? If the governing body chooses to quote, take no further action,
I think that
what happens in your view of D?
I think that it's a de facto denial.
Okay, but if that's the case, the problem you were describing doesn't exist.
Well,
There is no eternal return.
if two of the three decision makers in the governing body don't support that action, I don't think that you can get to that point. If you've got two people that support the action from the get-go, but they just don't have the super majority that would be required, when it comes back down, they can't, the simple majority wouldn't support taking no further action. And that's where I run into the issue.
Wouldn't they have no choice? I mean, in other words, subsection D doesn't provide for, I think this was Justice Rosen's point, but I'm trying to get clarity in my own mind.
Thank you.
It doesn't provide for a second remand from the governing body to the planning commission. It's just not it's just not there. It's not in D, right?
I mean, the text of it, I agree with you, says that there's not a remand there, but I think that when you talk about the potential for the governing body making amendments, I think it's implicit in that. If the governing body is going to make amendments to it that haven't got feedback from the planning commission, I think they would be implicit in that idea. I want to shift gears while I've still got a little time and just touch base on the idea of reasonableness here.
And it's a threshold matter. If we disagree with you on the statutory interpretation and take Austin Properties interpretation, do we need to go to reasonableness?
I believe I would have to agree with Austin Properties on that issue. I think that you don't touch reasonableness if you find that the action that the governing body took was not one of the ones available to it.
Well, she wants us to go ahead and talk about it, apparently because someone would be interested in what we think about it. But we don't have to. In order to resolve the legal posture of this case, we would accept Austin Properties interpretation and remand back to the city council. And so you agree with that, right?
I do agree with that.
Do we rewind to, okay, it didn't pass with the 3/4, so what do you want to do? In other words, is there a 2/3 vote to kill it? Or amend it? Then you amend it or send it back?
I think that at this point in time, this many years afterwards, with a different composition of the governing body, I think it would be remanded with instructions to the governing body that their options are either approve it by a 3/4 super majority, override it by a 2/3 majority, or remand it to the planning commission. I don't think that with a completely different group of decision makers, it would be.
You don't want to be locked in to the failure to approve this 6 years ago by a 3/4 majority.
By a different composition of the governing body. I don't think that it would be fair to do that.
And before you get into the substance of your reasonableness argument, I'll ask you the same questions I asked Ms. Sherman. Do you agree that reasonableness is a question of law?
Yes, I do agree that reasonableness is a question of law. And
Okay.
so to address what I think your question was, which is
Why defer? Why, yeah, the deference question.
ultimately what this court has said is that the entity charged with deciding what's best with the city is the governing body. This court's role is simply to ensure that the governing body's decision is not arbitrary or unreasonable. That's why it's a question of law.
Well, I understand it's a question of law. I would agree that seems reasonable, but typically when we have questions of law presented to us on appeal, we apply a de novo review because we're in as good a position as anybody to draw the legal conclusions without deferring to, the decision makers along the way. I mean, if it's a fact question, we give deference, but not on legal questions.
Right, and I think this is a little different than a lot of the questions of law that the court typically considers, because ultimately, when you're talking, like I said, when you are talking about zoning decisions in particular, the deference is there because the citizens of Shawnee, Kansas elected their governing body to make those decisions and not the courts. And that's why the courts have been so hesitant to step in and say, as a matter of law, we can tell you how we've reviewed the record and we can all vote and decide how we would have done it.
Can I get your take on the question I asked your opposing counsel, which is, do you think that we are limited in the issues before us to the reasonableness question based on the language in 12-760?
As much as I'd like to tell you the answer to that is yes, I don't think I could do so truthfully. What the courts have told us is that under 12-760, the review is really it's limited, but it's limited to two things. Is the decision lawful and is the decision reasonable?
And so it was the Manly court just wrong when it talked about zoning decisions being, quote, both illegal and reasonable?
I think
Another,
that
I'm just asked, that seems to draw a distinction between the two.
it does, but the distinction seems to be contrary to the scope the court is consistently.
Well, if we're
applied.
concerned about being rigorous in our application of the plain language of statutes, 12-760 only talks about reasonableness, right?
I agree with you about that completely.
But it's basically your position is that reasonableness includes a lawfulness kind of concern, that it couldn't be reasonable if it was unlawful.
I think it would be difficult to say that the decision was didn't follow the procedure lawfully, but it was still reasonable.
Well, isn't that exactly what our precedent does say? I mean, it might be difficult, but that's what we said, right?
That's what it says in Manly. I do
Okay.
think when the court talks about the scope elsewhere, it says lawful and reasonable.
So back to my earlier question, is it fair to say, you're being polite, but is it fair to say your argument is that language, whether it's a holding or dicta or whatever, is just wrong?
I think that's correct. So shifting gears when we talk about reasonableness here, we're talking about the golden factors, and I think that and I realize my time's up. If I can
You can have a few minutes.
just touch on this briefly. I think that the record amply supports the basis for the governing body's decision. The key focus was on the density of the project as compared to ones in the past. I think ultimately the record shows that the density for this proposed project was something like 2 times as high as the most recent one, which, as the Court of Appeals noted, spills over into the issues of potential traffic, aesthetics, meaning the height of the building required to fit those number of people in there as compared to the mature subdivision in the area.
I'm just thinking, as we think about what the remedy is here, I would suspect that density, traffic, all of that has changed, I don't know dramatically, but has changed in 5 or 6 years. And so would that enter into our determination of what to do here?
I think
Because
that
what was reasonable 5 years or 6 years ago might not be reasonable now, just in terms of what the posture of the property is and the population shifts.
Well, I would say a couple of things. The density of the project, I would assume, would be static unless the applicant wanted to change it. But and I can't speak to the specifics of what has been developed in this area of Shawnee from the time that this application was submitted to today. But I agree with you that it does stand to reason that conceptually it could be that things have developed differently over the last 5 years. It's been a long time. Thank you. Those are my key points on the issue of reasonableness. If the court has no further questions, my time is up, and so I will rest. Thank you.
Thank you.
May it please the court again, Melissa Sherman for Austin Properties, the appellant. Wanted to start with the issue of deference. Question was asked about deference. And specifically also go back to why we would respectfully ask the court to look at the second issue. The Court of Appeals turns the whole idea of golden and the deference that has typically been accorded to or quasi judicial decision making on its head. And basically, there's a free-for-all. If a city council member hears a complaint from the public, they can deem that evidence. And that can be used to overweigh, controvert the expert testimony that's been provided by qualified professionals. In a quasi-judicial capacity, that should not be permitted. A council member should not be able to just determine that anything, a generalized complaint is evidence. And that's effectively what the Court of Appeals decision does.
Couldn't we just vacate that holding?
You certainly could. Also wanted to address the question on the sections being in conflict. Council talked about that. That was certainly something the Court of Appeals found. But of course, this court's guidance is that if there are sections of a statute that are in conflict, they should be harmonized. The Kansas Court of Appeals did not do that. And instead, as your honors indicated, or one of your honors indicated, read words into the statute that do not exist. Specifically, the Court of Appeals looked at subsection F and says under subsection F, if there is a protest petition, if you don't get a 3/4 majority, it fails. Those words are not in the statute. And as the court has previously indicated, we are not in the business of reading words into the statute that do not exist. There was a comment about gridlock and the city council being in a position where 2/3 of the members don't support doing nothing, then we're going to be in this position of a standstill. Exactly. If there is not a 3/4 majority to approve under a protest petition, as is required under the statute, it simply fails. That is precisely why there's language in the statute that the city council can take no action. That is the very essence of taking no action. The matter fails.
That's your position of what happens when it comes back.
That's correct. Yes,
If it doesn't pass by 3/4, it's done.
that's correct.
But what happens if the recommendation is to approve and the whole 2/3, I mean, it's not overridden, is it, unless there's a 2/3 vote contrary to the recommendation of the Planning Commission when it comes back?
And when it comes back, it's just a simple majority.
A simple majority.
And under those circumstances, if there's a protest petition, a 3/4 majority is required. But on a remand situation, unlike what's specifically provided for on the first look at the statute, there is no requirement that it go back. That's precisely why the statute speaks to taking no action. There was a comment about the city council not being permitted to make amendments if there is a remand and it goes back to the city council. Again, the statute specifically allows that. And if there is not on a protest petition, 3/4 majority that approves adopting or approving the amendment with amendments, then it simply fails. Unless your honors have any other questions, I think I've made the points that I would like to make.
See no questions. Thank you.
Thank you.
Thank you to both counsel for your arguments this morning. The court will take this matter under advisement. The court is now in recess until 10:30.
All right.